Mr. President, distinguished members of the Court, it is a great honor and privilege to appear before you on behalf of China. For over half a century, Palestinians in the occupied territory has endured persistent suffering, with many communities dependent on humanitarian assistance for basic survival. Following the October 2023, the escalation of the Palestinian-Israeli conflict, even this basic lifeline has been severely threatened. With each new restriction and every law Israel enacts to block assistance, the situation grows more desperate in Gaza and throughout the occupied territories. We are witnessing an unprecedented humanitarian crisis, threatening to overwhelm an already suffering people. The suffering of Palestinian people touches the very heart of China. For 12 straight years, President Xi Jinping has sent messages to the UN Special Commemorative Meeting in observance of the International Day of Solidarity with the Palestinian people, expressing China's unwavering support for Palestine's just cause. China continues to provide humanitarian assistance to the Palestinian people, while also participating in broad international efforts to alleviate the humanitarian crisis and support post-conflict reconstruction in Gaza. President Xi puts it simply and powerfully. I quote, "The humanitarian cause is humanity's shared mission," end of quote. This principle guides China's position that the United Nations, as the cornerstone of multilateralism, should play both a central and unique role in leading and coordinating humanitarian assistance. As the stakeholders in this humanitarian mission, all states should work together to provide humanitarian assistance to the Palestinian people. Ultimately, the fundamental solution to the Palestinian question lies in the implementation of the two-state solution. This addresses the core of this conflict: Palestinian people's fundamental right to self-determination. At the same time, Israel's legitimate security concerns should be respected. China champions the parties to move forward each other and stands ready to work with the international community toward early realization of this vital goal. Two states living side by side in peace, their peoples sharing the benefits of friendly coexistence. China submitted its written statement to the Court in February 2025. Today, I will present China's view in three parts. First, the advisory jurisdiction of the Court. Second, Israel's obligations as the occupying power to the UN. Other international organizations and third states, namely third parties. Finally, Israel's obligations as a member state of the UN. China submits that the court has jurisdiction over questions requested by the General Assembly, and there's no compelling reason for the court to decline to exercise its jurisdiction. China supports the court's exercise of its advisory jurisdiction in accordance with international law. China hopes that the court will focus on the specific legal questions requested by the General Assembly, building upon its advisory opinion of the July 2024 to provide legal guidance on relevant issues. The guidance will serve to promote lasting peace, stability, and development in the Middle East. Moreover, it will safeguard international peace and security by upholding the authority of international law and advancing international justice and fairness. Mr. President, I now turn to the obligations of Israel as occupying power in relation to the third parties. Since 1967, Israel has been the occupied power of Palestinian territory, including the Gaza Strip, while Israel withdrew its physical military presence from Gaza in 2005. This did not change the status as an occupying power, a position this court affirmed in its OPT advisory opinion. In armed conflict, particularly in the situations of occupation, Israel's obligations as occupied power, specifically in relation to the third party's presence and activities, derive from two fundamental sources of law: international humanitarian law and international human rights law. In terms of obligations of Israel as occupied power under international humanitarian law, four fundamental sources should be noted: the Hague Regulations, the Fourth Geneva Convention, the First Protocol, and customary international law. From these sources emerge five principal obligations, which I will examine in turn. First, Israel has the undisputed primary responsibility to ensure the basic needs of civilians in the occupied territory. The obligation explicitly required by Article 55, paragraph 1 of the Fourth Geneva Convention and Article 69, paragraph 1 of the First Protocol. These provisions require Israel to ensure to the fullest extent all supplies essential for civilian survival in the OPT. Second, Israel has obligation to agree to humanitarian assistance from third parties when the population in the OPT is inadequately supplied. This is not a discretionary choice. Refusing such assistance could constitute denial of humane treatment of civilians or a form of collective punishment, both prohibited under international law. Third, Israel has obligation to allow and facilitate humanitarian assistance from third parties in three specific ways. Israel shall ensure rapid and impeded passage of the humanitarian assistance, enable humanitarian personnel to perform their tasks and facilitate the distribution of relief materials. Fourth, Israel has obligation of respecting and protecting humanitarian assistance personnel and materials provided by the third parties. This entails a negative obligation to refrain from causing harm to them and a positive obligation to take active measures to protect them. We are deeply concerned about casualties among humanitarian assistance personnel in the OPT. We call on all parties to comply fully with their obligations under international humanitarian law to ensure the safety of humanitarian assistance personnel. Fifth, Israel has obligation not to, for the purpose of civilian starvation, impede humanitarian assistance from the third parties by using siege or blockade. When siege or blockade are not prohibited per se as a method of warfare under international humanitarian law. These methods become unlawful when intended to starve the civilian population. Moreover, as confirmed by the court in its OPT advisory opinion, Israel, as an occupied power, has no sovereignty over or no right to exercise sovereign power in any part of the OPT. In addressing the humanitarian crisis in Palestine, multiple Security Council and General Assembly resolutions confirm and reaffirm Israel's relevant obligations, providing valuable guidance for the present case. It must be emphasized, Mr. President, the principles and the rules of international humanitarian law cannot be derogated from unless explicitly provided for. In practice, the occupying power may impose appropriate restriction on the presence and activities of humanitarian assistance only under specific circumstances, which I will now outline. First, activity and movement of humanitarian personnel may be restricted only in a case of imperative military necessity. These restrictions face two critical limits. They cannot constitute a complete ban on humanitarian activities, and they must remain temporary, not permanent. Notably, these restrictions are not applicable to humanitarian materials. Second, specific humanitarian arrangements may be subject to temporary technical restriction based on the reasons of security. However, such restrictions cannot amount to either a denial of humanitarian assistance presence or a general prohibition on the access of the humanitarian assistance. Third, providers of humanitarian assistance may be subject to appropriate restrictions on their presence and activities. If they violate humanitarian principles of humanity, neutrality, impartiality, and independence. These restrictions must be based on sufficient legal grounds and factual evidence, and each case must be evaluated individually. When misconduct occurs, restrictions apply only to the specific individual involved, unless such conduct is proven attributable to the organization or state. As a matter of international humanitarian law, humanitarian assistance is based on two pillars: the occupying power primary responsibility and third parties humanitarian assistance. Unlike the occupied power primary role, the third party play subsidiary and complementary role. The rule applies only when two conditions are met. First, the civilian population's basic necessities are not adequately supplied. And second, the occupied powers has given its consent. Such assistance must adhere to humanitarian principles when respecting technical arrangements established by the occupied power under international law. China knows that. A few written statements assert that the occupying power has a broad discretion to accept or deny the presence and activities of the third parties that provide humanitarian assistance. However, international humanitarian law explicitly constrains such discretion by establishing two distinct obligations. In situation of occupation, the occupying power shall agree to humanitarian assistance from third parties. In situation of armed conflict other than occupation, humanitarian assistance from the third party shall be undertaken, and the parties to the conflict shall not arbitrarily withhold their consent. In the situation of armed conflict, international human rights law complements international humanitarian law. Israel is a party to several key international human rights conventions. These conventions apply to acts done by a state in the exercise of its jurisdiction outside its territory. Therefore, Israel is bound by these conventions in its conduct in the OPT. Israel has occupying power, is obliged to respect, protect, and fulfill the human rights and fundamental freedoms of Palestinian people in the OPT. These obligations include a full spectrum of rights, including Palestinian people's right to self-determination, life, work, an adequate standard of living, as well as the right to food, healthy, and education. More attention should be paid to the protection of the right of vulnerable groups, including children, women, and persons with disabilities. With respect to the humanitarian and development assistance, Israel is obliged to cooperate with the third party to ensure fulfillment of these human rights. This entails both positive and negative obligations. Israel shall actively facilitate humanitarian and development assistance, while refraining from creating obstacles to such assistance. Among these fundamental human rights, self-determination constitutes a collective and fundamental human right, serving as prerequisite for the full enjoyment of all other fundamental human rights. The Court has affirmed that Israel, as an occupying power, has obligation not to impede the Palestinian people from exercising the right to self-determination. A key element of this right is that a people may freely pursue its economic, social, and cultural development. The right is also fundamentally linked with the right to development. Declaration on the Right to Development states that the human rights for development implies the full realization of people's right to self-determination. Under the Declaration, every human person and all peoples are entitled to participate in, contribute to, and enjoy economic, social, cultural, and political development. It necessarily follows from that, given the Palestinian people's right to self-determination and their right to development, Israel is under the obligation to facilitate and promote, rather than to impede, humanitarian and development assistance from the third parties. Moreover, Israel is under the obligation to take provisional measures indicated by the Court in the case concerning application of Genocide Convention to the Gaza Strip, and to comply with the Court's specific demands regarding humanitarian assistance. Mr. President, I will now turn to the obligation of Israel as a member state of the UN in relation to the third parties. These obligations flow from three sources: the UN Charter, the Convention on the Privileges and Immunities of the UN, and the General International Law. Under the UN Charter and the General Convention, Israel undertakes the following main obligations in relation to the third party at all times. First, Israel is obligated to cooperate with the UN and other member states in providing humanitarian assistance. International cooperation is a fundamental principle of international law and a core purpose of the UN Charter under Article 1. This obligation to cooperate is set forth in Articles 55 and 56 of the Charter. Israel shall give the UN every assistance for any action taken under the Charter, including but not limited to Chapter 7 enforcement measures. Israel shall fulfill in good faith its obligation to cooperate, to safeguard and facilitate the provisions of humanitarian assistance by the third parties in the OPT. Second, Israel has obligation to ensure the privileges and immunities enjoyed by the UN agencies and bodies. These include the inviolabilities of the premises, the immunity from executions for property and assets, and the tax exemptions, among others. Third, Israel has obligation to ensure the privileges and immunities of the UN personnel. These includes immunity from legal process and travel facilities for UN officials, as well as the privileges and immunities of experts on mission. With that being said, I now move on to address Israel's specific obligation in relation to the UNRWA. UNRWA is backbone of humanitarian assistance operations in Gaza. Its role in alleviating the humanitarian crisis in Gaza is both indispensable and irreplaceable. As subsidiary organ of UN established by the General Assembly, UNRWA is entitled to all rights and privileges accorded to the UN organs by international law. In fulfilling its obligation toward UN organs in good faith, Israel shall safeguard and facilitate UNRWA humanitarian operations, protect the safety of the personnel, and ensure its privileges and immunities. By withdrawing from the 1967 interim agreement and enacting legislation to prohibit UNRWA operations, Israel clearly violates its obligations under international law. As set forth above, such action contravene a fundamental principle of international law. No state may invoke its internal law to justify non-compliance with the international obligations. While differences may exist regarding the implementation of the interim agreement, Israel is required to consult and negotiate with the UN in good faith to resolve these matters properly. With respect to Israel's obligation concerning UN peacekeeping operations and their personnel, I wish to make the following observations. The UN peacekeeping operations play a vital role in restoring and maintaining international peace and security. As subsidiary organs of the UN, these operations enjoy all privileges and immunities accorded to the UN. For the UN officials and experts on mission in peacekeeping operation, their privileges and immunities are guaranteed under the General Convention and the relevant international practices. Personnel serving in the national armed forces under their standing states' command and control are protected through status forces agreements between the host state and UN. Where no such agreement exists, customary international law provides these forces relevant immunity afforded to all state armed forces. The Security Council and the General Assembly have adopted a series of resolutions strengthening the importance of ensuring the privilege and immunities of UN, its agencies and bodies, and their personnel, as well as protecting the safety of UNRWA. UN peacekeeping operations and their personnel. These resolutions reiterated the international law obligation that Israel shall fulfill in good faith. As a final point, general international law imposes two obligations on Israel in relation to the third parties in the OPT. First, Israel shall respect sovereign immunity of states, immunity of state officials, and diplomatic and consular privileges and immunities of third states. Second, Israel cannot exercise sovereign power in the OPT, including any attempt to prohibit UNRWA's presence and activity. Such sovereign powers rest exclusively with Palestine. Mr. President, the Palestinian people face no greater urgent threat than deprivation of humanitarian assistance. While the court advisory opinion of July 2024 still echoes, the reality of occupied Palestinian territory remains grim. Occupation continues and the starvation persists. The desperate eyes of Gaza's children pierce our conscience with two burning questions. Will international law surrender to the brute force? Will the pillars of civilization yield before the law of jungle? China respectfully calls upon the court to issue an advisory opinion that upholds the integrity of international law and stirs the conscience of international community. Only by safeguarding fairness and justice through the rule of law can we build a community with a shared future for humankind. Mr. President, distinguished members of the court, that concludes China's statement. On behalf of Chinese delegation, I wish to thank you for your patient attention. I extend my appreciation to the registry and the staff for their kind support.